Hello and welcome to Moneylife News and Views. I am Debashis Basu. We all know how difficult it is for property owners to get their money back when the project goes into liquidation or bankruptcy. Now, here is a story that I'm going to narrate this week, which shows how egregious the situation can be and how nobody is interested in solving the problems. In April 2009, C&C Towers Limited had signed a 20-year concession agreement with Greater Mohali Area Development Authority or GMADA to set up a big project that consisted of interstate bus terminal, 3 multi-story towers with retail and office spaces, a mall, multiplex, 5-star hotels, banquet hall, hypermarkets and so on. Now, having backed the contract, what did C&C Towers do? They immediately gave an advance of more than 111 crores as pre-construction advance and another 63 crores as further advance for mobilization of resources to a group company, C&C Construction Limited. And this was a listed company which is now into bankruptcy. As always, a bunch of public sector banks had lent the money. In this case, it was State Bank of India, State Bank of Hyderabad, State Bank of Patiala, Punjab National Bank and Punjab and Sindh Bank. Now, they had sanctioned the project cost in around November 2010, which is more than a year after the deal was signed with GMADA. Apparently, C&C Towers, as the real estate developers all do, went out and collected advances even from those who wanted to invest in this project, who want to own parts of the office buildings and so on. That was about 490 crores from 400 property buyers. So anyway, C&C was fully funded, maybe twice over or thrice over. Construction was inordinately delayed, leading to GMADA invoking the bank guarantees. SBI and PNB, SBI, all of these, the State Bank of Patiala, Hyderabad, etc., got merged with State Bank of India. So it remained SBI and PNB as the main financiers. What did they do? They involved Edelweiss ARC for some sort of a restructuring agreement. We don't know what that is. What restructuring would such giant banks like PNB or SBI need from a small company called Edelweiss ARC? We don't know. Eventually, it became a bankrupt project, so it came under Insolvency and Bankruptcy Code. But IBC was meanwhile passed sometime in December 2016, so the project came under IBC. And Corporate Insolvency Resolution Process, or CIRP as it's called, started in October 10, 2019. This is like 10 years after the project started. Now, when the resolution professionals started looking at it, there was about 399.8, almost 400 crores was in capital work in progress. And all of the creditors' dues amounted to 580 crore. So there was a gap of just about 100 crore. And people would have got 75% of the money back. But no. Finally, when they started doing the tally, when they started doing how much each one is going to get, the banks were going to get only about 13.3%. And that too as an upfront payment of 1 crore and the rest in installments over 5 years. Fixed deposit holders were going to get only 12.8%, and the allotees, which is the property owners, only 10.6%, and GMADA had to write off 90%, so they were going to get 10% only. And statutory dues was about 8%. In all this, just 72 crore was realizable, or 12.5% of the admitted claims. At the same time, the books of accounts showed 400 crores of capital work in progress. Now, so where did the 400 crore of capital work in progress go? Which the value of that should have by now doubled or should have become more. In all this, the question is, what were the bankers doing? What were the engineers, independent engineers who were supposed to inspect the project at various stages of GMADA doing? The answer is crystal clear in all such bankruptcy cases where 80%, 90% is being written off. And these especially involving public sector banks. But the answer is one we don't want to see. And that is rampant fraud and corruption by everyone who is involved. We like to believe this is not large-scale loot, but simply business failures. Of course, there are provisions in the IBC to identify fraudulent transactions, and these are collectively called PUFE, and that stands for preferential, undervalued, fraudulent, and extortionate transactions which the debtor had actually done, and these can be clawed back. These transactions are supposed to be added back and recovered from the corporate debtor. Was it done in this case? No. Well, the parties involved have managed to fix this too. Preferential transactions of only 1.85 crore paid to two companies of the CNC group were recorded. Undervalued transactions of just 91 lakhs were identified. Nothing was identified as extortionate, and fraudulent transaction was just 2.51 crore. During this process, it also appeared that some 91,000 square feet space was sold thrice over to the extent of 2,90,000 square feet. Now, all this came out when the resolution professionals managed to get in a new buyer, which is called Mahakram Developers. Now, very recently, I think just last week or today, the High Court has announced that this is a fraudulent transaction which is being entered now all over again. And because of this, all these major write-offs, 80%, 90%, the loot that has happened, all these write-offs are happening. Now, like the story of the three monkeys, we don't seem to see, we don't seem to hear, and we don't want to talk about rampant fraud and corruption leading to IBC cases, especially those involved in public sector banks. Now here, look at the situation of the bankers, what they did. They financed the project after the engineering, procurement and construction contract was signed with the related parties, that is CNC Constructions, but they did nothing to rectify that contract, which drained away all the money to the group companies. They failed to monitor the project and take timely corrective action. Further, they transferred the loans to CNC to Edelweiss under a restructuring agreement. Clearly, the banks are primarily responsible for this fraud, but they got away. Yet, there is widespread opinion, even articulated by former RBI Governor Raghuram Rajan, that opposes criminal action against bankers. Apparently, this would demoralize them from taking decisions. What about those PUFE transactions? The regular process of identifying PUFE is toothless, even in a case like this, where EPC was handed over to the benefit of the CNC Constructions or individuals. What is needed in each such cases is a forensic audit, not merely of the accounts, but of the whole project. But this cannot be mandated. There has to be some commercial incentive for such an investigation, unless we bring in an interested party who would go after the various people involved and unearth these transactions for their own benefit, probably because they get a percentage of it. This is never going to happen. What about the promoters? They crafted the EPC contract so that the money of almost 163 crores is drained away right from the beginning. All that's very, very legal because there's no PUFE transactions. While the chairman and the director were arrested, Harbhajan Singh Jolly, who was actually leading the fight on behalf of CNC Mohali Junction Clients Association, he alleges that the police gave the company officials a clean chit in a case which is of outright fraud. GMADA, which is Greater Mohali Area Development Authority, they have engineers who were supposed to inspect the project. They failed to monitor the project. I am not sure if those engineers had to pay a price for it. The most amazing aspect of this mess is that the main victims, the allottees, have no say in this vile affair from start to finish, or have a very, very minor, insignificant say. It's all technical. They had no means to monitor the project. They're all individuals scattered all over. The job of monitoring was with the bankers, or was with GMADA. They were tricked by the presence of the compromised government-owned banks and GMADA in this whole affair. They got no help from the law enforcement agencies because the company officials have got away after a few arrests. And finally, they have been relegated to rank outsiders in the RBC process, also, although technically they are now unsecured creditors. According to banker and resolution professional Dr. Rajendra Ganatra, it is the property buyers who fund the project. They fund the entire debt payment and the entire equity servicing. All the money, the revenues actually come from the buyers, nobody else. And yet, they until recently had no locus in the IBC process. In fact, until the infamous cases of cheated home buyers such as Amrapali and JP Infratech began to hog the media headlines day after day, home buyers' rights were completely ignored. Then the Supreme Court looked at all these complaints and merely gave them the status of unsecured financial creditors. That is hardly enough. They are the actual property owners and they have funded the project. It's their money which the promoter gets and the bankers gets and everybody else gets. Their rights should be on par with the secured creditors, with the secured lenders, or even superior, because they were under no legal obligation like the bankers were or the other people in this process were and the promoters were. And in any case, they have no institutional resources like these people to monitor the project. They are the victims and they are the owners. Real estate bankruptcy laws today do not reflect this sordid and sad situation. These laws should be completely overhauled with giving them these rights and correcting this egregious wrong. But how is this going to happen? Who's going to speak for the disparate and widely spread property owners today? Thanks for watching.